rise. The Court of Appeals, Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is a time set for oral argument in our case number CV19-00074, Martin versus Staheli et al. We will, each side is allocated, 20 minutes for oral argument. I'd ask that you keep that in mind as you present your argument. Appellant may reserve a portion of that time if you wish to do so. If you wish to do so, you need to keep track of your own time. Out of respect for counsel, I would ask that everyone in the court make sure their cell phones are off to avoid interruption and embarrassment. We have read the briefs. We've conferenced the case this morning. We'd encourage you to keep that in mind as you present your oral argument. Our proceedings are being recorded and then will be posted on YouTube after a time. So as you are beginning your oral argument, please state your name and the party that you represent. With that, Mr. McNamara.
If it please the court, Mike McNamara for the appellant, the Martin family. What I'd like to try to add to the briefing today is really to address 5 questions. First, the viability of the economic claim, which the court did not permit. What I believe the defense in this case is saying about the loss of income claim, what they say the law is, and what my argument is to the effect that their representations as to what law they're relying upon is that it doesn't say what they're telling you it says. Conversely, the third thing I'd like to attempt to do is persuade the court that the law that I'm citing to the court with regard to the viability of the loss of income claim does say what I represent to the court that it says. I have one brief comment about the abrogation issue, which I think is a little bit of a rabbit hole, but I think is worth stating. And if I have time in conclusion, I'd like to mention what I think is really going on here in this appeal with regard to the issue presented. With regard to the economic claim for the estate, the parties agree that it's a viable claim. The law clearly provides we are entitled to pursue this claim on behalf of the estate. The only issue presented is whether we raised it with the trial court. And I've briefed it as well as I can, I think. I'm happy to go over it again. By my count, there was about 7 opportunities for anyone looking at this to understand that we're making a claim for the estate, for the economic loss, which is the only claim you can make for the estate. It's a motion to amend the claim for the estate. Here's attached draft proposed amended complaint. The economic claim is there. The economic claim was there before he died. It was timely brought.
I thought you just had to make a substitution for the estate.
Yes, I did.
The original complaint didn't.
That's right, Judge. The original complaint has a claim for economic loss for Mr. Martin. He dies. I timely and appropriately moved, as required under the rules, to substitute the estate for Mr. Martin and assert the same claim that's already there. All I'm doing is substituting parties, the estate for Mr. Martin. And again, I can go through that, but it seems to me very. And then we file a motion for reconsideration. The court does a rule on it. I brief it in detail. To say that they didn't know, we even have a meet and confer on this. There was no objection in response to the briefing. There was no objection to meet and confer. It's in the heading of the caption. It's in the proposed amended complaint. So I view that as really almost a spurious argument to raise on appeal.
Well, you had a motion to amend to add additional parties, correct?
Yes.
The children.
Yes.
Is this something that just got lost in translation with the Superior Court on the economic claims? I mean, he's looking at the amended complaint, and yet then he dismisses the economic claims. I don't understand.
I don't either, Your Honor. So yes, I think something was lost in translation. My view is that it's such a basic or fundamental rule of law practice with regard to personal injury cases that you substitute the estate for the deceased person. And it's a separate issue from the issue as to the loss consortium claim, which I attempted to bring on behalf of the children. The wife's loss consortium claim was originally pled and still in the case, but that was likewise dismissed. May I move on to the consortium claim? Again, I'm happy to address the economic claim, but I think it's a smaller issue in the case. In Arizona, the law is very clear that we allow for loss consortium for family members in personal injury lawsuits. We also allow for loss consortium in wrongful death cases. And the law is very clear that when we're talking about minors, the Arizona Supreme Court has said they have an independent claim for their loss, and it can be brought 3 years later, it can be brought 5 years later, it can be brought 20 years later. The statute of limitation is told for minors' loss portions claims, and that means there can be separate lawsuits. And duplicative litigation, unless the defendants choose to bring the children in themselves, and their position all along has been, the injury wasn't big enough, it wasn't serious enough to reach the threshold. And yet on appeal they say, oh, statute of limitations as to the children. I put some detail in my briefing as to what the injury was and what the course of the lack of recovery was, so the court would appreciate why I brought the claim for the children when I did, and what the nature of the injury was that established the basis for that claim. So the defense says, well, of course there's a claim in death cases, there's a claim in personal injury cases, but if there's a claim in a personal injury case and then the person dies, there's no claim for the intermediary period of time. That's what this appeal is really all about. If the person passes before the case is resolved according to the defense, whether it's 3 years or 20 years, the claim is barred. The trial court agreed, relying upon the survival statute, which the defense agreed does not apply. The plain reading of the survival statute clearly provides that it doesn't apply, and it's obviously my contention that the survival statute doesn't apply. So the question is, well, why? Why would that be the case? What is the reason for that? And the defense argument is there's a derivation theory. The defense contends that if the personal injury victim dies, the family's consortium claims die with him because the personal injury consortium claims are derivative of the deceased consortium claims for personal injury, pain and suffering.
Now, Mr. McNamara, you would agree that once Mr. Martin passed, the consortium claim from the family, the damages would have ceased because the death was unrelated to the
I'm sorry, the damages. I'm sorry, the damage.
Claim for the damage stops because the death was unrelated to the alleged tortious activity.
Absolutely, we agree. We're just talking about the 3-year period of time.
Okay.
That's all that's at issue here.
So we're talking about whether or not the Milga claim for consortium, or loss of consortium, is it derivative from the consortium claim of the victim, or is it derivative of the tortious activity?
I think that's well put, Your Honor, yes.
Isn't that the crux of the issue we're talking about?
I think it is, yes.
Okay, now I want to ask you this hypothetical. Can a family member bring a loss of consortium claim if the alleged victim could not bring it?
Yes.
What authority do you have for that proposition?
Well, the restatement of torts on point, the Villarreal case, all of the Supreme Court cases, Bradford, Villarreal, Frank, they all say that these are independent claims which have evolved over time, and I want to talk about the evolution and where we've come from, which is what I think the defense is arguing we go back to. The Supreme Court over and over again, in just incredible detail in terms of their reasoning, say these are claims to compensate these people for their loss. They're separate claims. They're effectively independent claims. That's what the restatement says. That's what a half a dozen other states have explicitly ruled. it's become somewhat academic because if the person ultimately dies, in most states the consortium claim is subsumed by the wrongful death statute, and you end up in the same place. But yes, Your Honor, I appreciate the question. I think it goes to the heart of the matter, and the answer is substance and reality over form and procedure, and illogical logic, i.e., what we're trying to do when we award...
Well, let me stop you there.
Sure.
So if an alleged victim passes, well, if the alleged victim fails on his or her claim for tortious conduct, whatever it may be, goes to trial and he loses it, doesn't that preclude any of the other family members from alleging loss of consortium for the underlying or the substantive claim?
Yes, if they're in, except with regard to minors, if they're in the same case. I mean, I think that basically they make four arguments to support this contention that, well, if the deceased person's pain and suffering is gone, therefore the survivor's pain and suffering is gone. They make basically four arguments, and the first one is the point the court is asking me about, and that's what I call the element cases. That's Lomar, Ochoa, Pasco. All those cases say, well, if they can't prove for the deceased person, if you can't prove breach of the standard of care, that's the Ochoa case. The plaintiff injured person was a trespasser, so there's no breach of the duty. Yes, the consortium claim for the children and the wife go with it. Lohmeyer, there was no causation to the injured person. Therefore, there's no remedy for the wife and the children. Pasco, it's got to be the same comparative fault. I couldn't agree with that more. But those cases don't answer our question or solve our problem. Those cases beg the question. They beg the question of if the elements could be met or the elements are met and the victim subsequently passes, should we not compensate the other people who have met the elements of the case? Those are what I call elements of the case cases. And Judge, on this issue, I would ask the court to read the Pasco case, which is a case relied upon by the defense. And I missed this in my original briefing. And I think that this might be responsive to the court's question. In the Pasco case, what they ruled was basically the allocation of fault that's going to apply to the tort victim's claim is going to likewise apply to the consortium claim, which makes complete sense. I agree with it completely. And they're trying to get to the ultimate decision, and they're reviewing the law, and they quote Prosser and Keaton's on this issue before the court. And here's what Prosser and Keaton says. They talk about this claim for the consortium as derivative from the injured person's injuries. And they talk about that as a traditional approach. Despite the weight of authority, legal commentators have long questioned this traditional approach and indeed lean on the side urged by the appellant, that's the plaintiff. And Prosser Keaton says, the conflict that appears to be developing in the cases suggests the need for basic explanations of which there has been something of a shortage. Courts have commonly said that the consortium action is derivative and must fall with the main claim, but as they could have well as said that it is independent. This sounds more like a conclusion than a reason, but it must also be observed that the label independent action for the consortium claim is equally a conclusion. In the end, the reasons for adopting one line of cases or another may turn less on logic than on perception of social needs and justice to the parties. And that is really their best argument is, well, there's some cases that say when, if the tortfeasor's claim is not viable because of no causation, no breach of the standard, statute of limitation, et cetera, then the consortium claims fall. And I couldn't agree with that more. It begs the question of, well, what happens if the tortfeasor dies, but the elements could be met? And that's the best they have. They have three other arguments. One is they cite to, for example, the Campbell case, which is a big zero. It's just dicta on the definition of the words bodily injury in an insurance coverage case. It doesn't move the ball at all. Then there is citation to a whole line of Florida cases that will make the court's eyeballs bleed if you really study them. But those cases are all based upon a statute in Florida that says if the personal injury results in death, and in our case the personal injury did not result in the death, it didn't cause the death, there's no action for the personal injury which will survive, and any such action pending at the time shall abate. We don't have that statute, and we don't have those facts. But read those cases closely. Read the Taylor case from Florida, which is...
well, not if it's going to make my eyes bleed. I'm not reading.
Okay, well, that case says, the Taylor case out of Florida says, oh, by the way, we agree with Mr. McNamara. The consortium claim is an independent claim, and it's a common law claim. It's not abated by the statute. There's a conflict between the appellate courts in Florida. It's all neither here nor there because you end up in the same place under those cases. So the last argument that they have is kind of this group of oddball cases that really don't move the ball. They cite the Stengel case, where a lost consortium claim was brought by a woman after the death of her husband, and she was divorced before the death. I mean, that just takes us nowhere. There's the case that says, well, personal injury lawsuits are preempted by the workers' comp, including the consortium claim. Well, also, it doesn't address our issue. There's the Mays case from Texas, which says that the statute of limitation on the adult's claim controls a minor's consortium also. Well, first of all, that completely conflicts with Villarreal. That's been rejected by the Supreme Court in Arizona. And also, if you read Mays closely, again, it supports my argument. It says loss of parental consortium claims are not entirely derivative, but rather they are separate and independent claims that are not automatically extinguished for particular purposes. That's the defense argument. That's why I say what they're telling you the law is not accurate. So what do I have? What do I have on supporting my argument? What I have is 5 states, Mississippi, Connecticut, Iowa, New York, Florida. If you check the restatement, you'll also find explicit cases right on point in Missouri that all say these are independent claims. They have the magic language that these are separate, freestanding, separate torts to compensate the family members who have a real loss. You have the restatement itself.
The only problem I have with those statements that you're making is they're not completely freestanding because they are derivative of the original tort claim. And that's what goes back to when I asked you the hypothetical in the beginning. If the original tort claim fails,
yes,
there is no consortium claim.
I couldn't agree with you more, Judge.
So they're not independent. A
They
litigant
rise-
doesn't have to keep defending over and over and over on the original tort claim.
Well, no. I mean, it's got to be one case controlled by one statute of limitation. The defense can consolidate them. And, but certainly they arise from the same facts. You have to prove the same elements, and it's due to the relationship with the deceased. That's what derivative means. Derivative has never been interpreted to provide what the defense is saying, and that is this. And I think that if I had to distill this case down to one sentence, I would distill it down to what the court wrote in the Harrington case. What they're saying is, look, the pain and suffering for the tort victim, his claim is gone. Therefore, the pain and suffering for the living should be gone. What the Harrington court said was the legislature apparently contemplated that once an injured person is dead, he cannot benefit from an award of his pain and suffering. They didn't say that the living family members wouldn't benefit from being compensated for their pain and suffering, but that's exactly what the argument is here. If you try to translate what is being said, which is, well, his pain and suffering's gone, therefore theirs is, that conflicts with Harrington. So I think basic justice, basic logic, consistency in the law with regard to the consortium claims really mandate a reversal in the consortium claim. And I'd like just to reserve 1 minute to give you my final pitch as to what I think this case is really all about, which I really haven't gotten to yet, but I'd like to reserve the last minute to do that.
Very well. Thank you, counsel. Ms. Gilbride. And perhaps others, but I...
I'll do the short straw, Your Honor. Eileen Gilbride for the defendants Kavanaugh and White Mountain Radiology. At counsel table are counsel for the other co-defendants, but I'm going to be speaking for everybody unless you have questions for them.
Very well.
Let's just get the motion to amend out of the way first. I really don't have much to add to our briefs. The motion to amend did not argue that the estate should be substituted in for the husband. The only mention of the estate was in the title. There was no argument on that. And remember, we're here on an abuse of discretion standard. When the motion didn't argue it, the emails that were attached to the motion spoke.
But, you know, I'm really having a hard time with this argument. You were put on notice that he died early on at his status conference. And then they said, oh, by the way, we're going to move to substitute in the estate. And
where did they say that? What they
at that hearing, and they said, oh, we're going to, okay, well, we're going to, and they said we're going to add the children.
They did say we were going to add the children.
Right.
That's the emails attached to the motion to amend.
So they moved to amend because he died. You knew that he had died. You knew that he had not, that there were economic claims still viable, not only for him, but for Mrs. Martin as a community property person who still would have economic interest in any economic damages that could be alleged. And what lack of notice, what did you need to know?
It's not lack of notice to us, Your Honor. The question is whether there was an abuse of discretion in the trial court when he read the motion to amend, which went on and on about the kids, which attached emails addressing the kids and not the estate, when the reply said kids, 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 nothing about the estate. When at oral argument, nothing was said about the estate. Only the kids, only the kids. Did the court, under those circumstances, abuse its discretion in saying this amendment is about the kids?
Okay,
and
except
let's
the
go.
Substitution rule specifically says it should be granted unless there's prejudice to the not to the judge, but to the litigants. Did you allege any prejudice?
Well, counsel didn't follow the Rule 25 procedure. There wasn't a motion for substitution and, all of the procedures that go along with that. There was, all we had, or all the trial court had, was a motion to amend. And a motion to amend that said kids, 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 that attached emails, kids, 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 that had a reply, kids, 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 oral argument, kids, 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 no estate. Did the court really abuse its discretion in thinking this amendment is about the kids? It has to be an abuse of discretion. I would just argue on this record, it's just not an abuse of discretion when the...
And so then when they moved a new trial pointing out this alleged error, did you correctly point out in your response that, they're right, it was a substitution and that you did nothing to that effect?
Because they didn't move. They didn't include the estate in their arguments, in the motion, in the reply, or in the oral argument.
But the proposed amended pleading was lodged, I should say, with the court.
It was an Exhibit 4, I believe, to the motion to amend.
And
I don't know if the court got to Exhibit 4 or if it just read motion, 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 kids, kids, kids.
You know the record better than we do, but that's sort of the operative thing, right, that was being tendered. And that did have the estate.
Well, yeah, it did. It did say, it didn't allege that she had been appointed personal representative, but that's whatever. It just substituted in her as executrix, I believed, in the caption. But, I mean, again, we're here on an abuse of discretion. Did the court, reading the motion, if you were sitting in the court's chair, reading the motion, oh, kids, 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 reply, kids, 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 oral argument, kids, 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 was it really an abuse of discretion for...
To get back to Judge McMurdy's question, at what point did you allege or establish any prejudice? Because I believe that's what's required to deny one of...
I don't recall seeing that in the record, an establishment of prejudice. I'll move on to the consortium issue unless you have questions on the amendment issue. Again, I think we've pretty much laid that out in our brief. In order to have, for a viable consortium claim to exist, the decedent must have had a viable injury claim. So I think counsel was mistaken in arguing and answering your question, Judge McMurdy, that if the injured party can't bring a claim, then I think he said the family could still bring a consortium claim. And the cases, of course, say that if the injured person can't bring a claim for whatever reason, if it's abated, if it's extinguished, if it's barred by the workers' comp scheme or whatever, then the consortium claim doesn't exist either. It extinguishes.
Don't you agree that and I agree that's what those cases say.
Yes.
But that indicates to me at least that when we talk about it being derivative of, it's derivative under the alleged tort claim and not derivative of the, in this case, the decedent's claim for consortium from the underlying tort claim.
Right, and that's respectfully, that's not our argument that it derives from his consortium claim. Our argument is that it derives from his hedonic damage claim, which is a little different because to me a consortium claim is the non-injured person is damaged by an injury to my family member. And here the family wasn't injured. So it's not the decedent's consortium claim that we're talking about. The decedent didn't have a consortium claim for loss of consortium of his family members, I don't think, because the family members weren't injured. But the decedent had his own hedonic damage claim, his inability to do the things and have the relationship with his family that he wanted and had before this injury. That is what I believe that's the consortium claim is derivative of. And here's why. It's not, and I think, Judge McMurdy, you said, isn't it derivative of the tortious activity? And it can't be because, well, first of all, in the Quadrone versus Pasco case, which counsel mentioned, 156 at 416, the court said, injuries of the consortium claimants are derivative from those suffered by the victim. So they're derivative of the injuries suffered by the victim. And that makes sense because...
Isn't that the tortious activity we're talking about?
No, because if you have, for example, let's say you have a tortious car crash. There's a tortious activity. Somebody runs a red light or whatever. If the victim, if you want to call him that, the injured person, isn't injured and only suffers car damage, but he's not injured at all, there's no consortium claim. It's just an economic damage claim. There's no injury to him. There's no injury to the relationship. There has to be a personal injury, a non-economic personal injury to him in order...
Okay, but that just means that there is no consortium, loss of consortium. That means that you can't prove your claim. It's not that if there was this tortious car crash that caused loss of consortium, the victim was in the hospital for 6 months.
Right.
All right.
Of course.
Then you can prove your claim, but you wouldn't. This is a motion to dismiss.
Right. But I think what Your Honor said was, isn't it derivative of the tortious activity? And that's why it's not derivative of the tortious activity, because you can have tortious activity with no personal injury. And so it would have to be a tortious activity with personal injury that allows the consortium claim to exist. And because it's derivative, the closest claim that the injured person has to what the consortium is derivative of, that was a little awkward, is hedonic damages, because the injured person is not able to do what the things that enjoy the life the way he wanted to before. He's not able to give care, comfort, and society to his family. That's what they're missing. That's the derivative nature. If there was no personal injury, there would be no consortium claim. That's.
See, this is probably going way far afield, but in preparing the arguments today, the original loss of consortium claim for common law was servant master.
Yes.
And the master had a loss of consortium claim. I think you're hard pressed to argue that a servant has loss of consortium from the master. So the master loses the benefit of having the servant around.
Right.
But
and that's why in the olden days there was no loss of consortium for the wife, only for the husband, because he was the master and she was the servant, and it didn't go the other way, as you were saying. Those days are over.
But I'm just saying, if that's the nature or the origin of what we're talking about, where it was a one-way street, why would we now switch and say, well, yeah, okay, but now it's got to be both. Both of them have to suffer before you can have a viability of the claim. Because the way I understand your argument is because husband can no longer maintain this claim, that the family members can no longer maintain the claim. But I'm not sure how that squares with the actual origin of this claim.
I'm not sure I can answer that.
Other than you just don't like it?
No, other than the law is that the consortium claim is derivative. I mean, if there is to be a change in the law, I don't think that this is the place to do it. It's been the law for at least 30 or 40 years, since the 1970s, that we have consortium claims and they're derivative. If the claim is barred by the injured party, or if he's, if it's extinguished or if it abated, the consortium claim also abates.
But it was a common law as well. If the servant was injured by tortious activity,
right,
the servant wouldn't have a consortium claim to the master, but the master would have a consortium claim against the original tortfeasor.
Okay.
So I'm saying, just because the victim, I'll cover it as the victim, a victim of the alleged tort, may or may not have a consortium claim is irrelevant. We're looking at whether or not the tortious activity caused a loss of consortium to someone else.
Right. And that's why I'm saying our argument is not that the consortium claim derives from his consortium claim. That's not our argument at all, so I think counsel misspoke on that. We've never argued that the family's consortium claim derives from the father's consortium claim. The father didn't have a consortium claim because the family wasn't injured. That, in my mind, am I not making myself understood? Okay, because when he was injured, that's his hedonic damage claim. That's what is derivative. That's what the family has lost. His ability to give them comfort, care, society, and all that. That's his hedonic damage claim. If he had if somebody else was injured in the car accident, and he lost, say, his wife's loss of care, society, comfort, that would die with him, because he's no longer around to experience that. But we're not talking about that here because the family wasn't injured. He didn't have a loss of consortium claim. So I'm not sure, we may be missing. I may not be understanding what the question is, but I mean, the law has certainly evolved that family members are entitled and have consortium with each other. And if one of them is injured, the other one is entitled to consortium as long as the injured one has a claim. I honestly don't have anything else to add to my arguments unless Your Honors have questions.
Thank you, Counsel. Mr. McNamara.
Thank you, Your Honor. Need I address the economic claim further? I mean, what I heard was, well, you didn't, when you moved to amend, you didn't mention the estate, explain the estate claim. I mean, the motion to amend was motion to amend complaint to add estate. And I attached the complaint alleging the same economic loss. Then they don't dispute that. Then I file a motion for status conference and motion for reconsideration, have a whole paragraph saying, Judge, you didn't rule on the economic loss claim for the estate. You didn't rule on the estate at all. Then I do a Rule 59 motion. I mean, to say I didn't rise it below is very upsetting to me because I did, like 7 times. And they obviously knew what was going on. What's really going on here, and when I step back from this thing and I look at the big picture, and I don't mean to be glib or diminish the seriousness of my client's claims, which are really serious, significant claims in my opinion. But when I first started reading this argument about, well, lost consortium's gone because the deceased person's lost consortium is gone, I thought back to a song on the radio from when I was in high school about 50 years ago. And from Tyrone Davis, he said his song was something like, you can't turn back the hands of time. And that's what's going on here. What they're saying is, well, we'll take away the lost consortium claim from the deceased person, and then we're left with a vacuum of law of nothing, and there's no specific thing that says there's a remedy for that, and we'll have no remedy. So what does that take us back to? It takes us back to where the law didn't recognize the familial claims, when it didn't talk about them as independent or separate or viable, when wives and children were viewed as property. If they got injured, it was a deprivation of services, a deprivation of property. Wives and kids were literally servants under the law, controlled by master-servant law. The husband had a claim for injuries to them, but they don't have a claim for injuries to the father. That's what's going on here. Let's go back to the days when women and kids are donkeys under the law. The Supreme Court in this case, the Supreme Court in this state has said over and over and over again in great detail, we've expanded the law of consortium. We've thrown out what it was. And by the way, it existed before the adoption of the Constitution. There was a wrongful death statute in Arizona in the late 1800s, and it's just evolved with mixed law. If you go read the Summerfield case, it explains the whole course of wrongful death and consortium claims, and it's
Mr.
a mix of
McNamara,
common law.
I see that your time's expired.
I'm sorry.
If you wish to wrap up in a sentence or two.
That's it. Just that the Supreme Court has said what we want to do is compensate the person that's injured, and that's these family members, and that's why we have familial lost consortium claims. And if we were to say, well, if the person ultimately dies, as they always will, whether we get it done before the case gets resolved, whether it's 3 years or 20 years, we're really reversing what the Supreme Court has held in all those cases.
Thank you, counsel. We appreciate your briefing. We appreciate your oral argument today. We'll take the matter under advisement. We'll issue a written opinion and a written decision in due course. The court stands adjourned.